Thank you, Mr Speaker, and I rise to make a contribution to the Children, Criminal Proceeding and Young Offenders Legislation Amendment Bill 2025, and I thank the Attorney-General for bringing this bill to the House. I indicate that I'll be supporting the bill. However, I do have some issues about the bill which I would ask the Attorney to address in his speech in reply to provide clarity and certainty pertaining to the interpretation of certain aspects of the bill, and I'll refer to those during this speech. I'll also carefully listen to those amendments put up by the opposition. In summary, this bill implements the recommendations of the independent review into the operation of doli incapax, a review undertaken by the former Supreme Court Judge and State Parole Authority Chair, the Honourable Jeffrey Bello SC, and former New South Wales Police Force Deputy Commissioner, Mr Jeffrey Loy APM. By way of background, this review was initiated by the government following the spate of serious juvenile offending conduct across many parts of essentially regional New South Wales, and that received widespread publicity and public commentary. Recent years have demonstrated the nature and objective seriousness which some young people are being involved in serious criminal conduct. Offences of vehicle theft and subsequent police pursuits, and driving in a manner dangerous, break, enter and steals, home invasions and serious assaults are not infrequent, and in some cases committed by children as young as 10, 11, 12 and 13. Criminality which not only placed the safety of those communities at risk but also the police and young offenders involved. Understandingly, this led to community outrage and the serious level of the offending conduct that these young people were committing. This, along with, in some instances, perceived leniency by the court or a failure for the police to successfully prosecute these offenders due to their age and doli incapax issues, understandably led the community to frustration, anger and fear. I note that the government has moved a suite of legislation over the last 3 years since being in government to address some of these issues, namely post and boast legislation and bail reform, and I welcome those. And I've witnessed firsthand, having been a member of the Law and Safety Committee, our current inquiry has been examining regional crime, especially youth crime. And over the last year, the committee has travelled the length and breadth of the state. And I noticed my friend, the member for Bathurst, who's also on that committee in the chamber at the moment. From Broken Hill to Bourke, from Wagga Wagga to Kempsey, listening to communities, speaking with stakeholders, victims, police, elders, land council, diversionary program directors, even offenders themselves. And we've heard that there are communities living in fear of being the next victim to a break and enter in the middle of the night while you're asleep in bed, or having your car stolen from your driveway and ultimately being involved in the police pursuit, crashed and sometimes set on fire. I've also spoken with offenders at the Arana Juvenile Detention Centre as part of our site visits that we conducted during one of these trips to Dubbo. And I spoke to them and asked these young offenders what led them to their offending conduct. These young people, well, some of them were from Orange that I met, a handful of them, who were being either on remand or serving sentences. Boredom and a lack of supportive home environment were the main motives. And I'll just say this on a side issue. I did hear the member for Newtown talk about these kids, and we're talking about a very small handful of children that end up incarcerated because of these offences. They're certainly not the majority of kids. But parents or carers need to step up and play more of a role in their supervision and parenting of these young kids. Many of these kids are out at 8, 9, 10, 11 because they don't feel safe at home. They're not being fed at home. They haven't got a safe environment. It could be domestic violence, could be drugs, could be alcohol, could be a whole range of factors. But talking about these kids needing to be tucked in bed and kissed goodnight, quite frankly, these kids don't have a home environment that provides that. And that's why they're out committing crime. Now I've lost my spot. As stated, the issue of this review and the focus of this bill centres around the issues of doli incapax. So what is doli incapax? Doli incapax is a 400-year-old Latin phrase which translates to incapable of evil, and in history dates back to the Middle Ages, originating in the English common law in the 1600s. The term is still used in courts across New South Wales today, 4 centuries later as a common law presumption pertaining to young offenders aged between 10 and 14. The common law presumes that a child aged between 10 and 14 does not possess the necessary knowledge to form a criminal intent. That is, that the child is incapable of committing a crime due to a lack of understanding or of the difference between right and wrong. It applies to children aged 10, 11, 12 and 13, and the presumption must be rebutted, and the onus is on the prosecution to prove beyond a reasonable doubt that the child knew that what they did was seriously wrong as distinct from mere mischief. And the existence of this presumption was affirmed, as we've heard other speakers talk about, in RP versus the Queen, where it was held that the defence and prosecution should consider doli incapax in all cases involving children under the age of 14. The seriousness of the act itself cannot be used as evidence to rebut doli incapax. That were some of the things that were held from that decision of RP versus the Queen. And some courts have grappled with its interpretation of doli incapax. And this bill will codify its interpretation into legislation, which will assist in guiding courts and legal practitioners to a fairer and more consistent outcome. So how can doli incapax be rebutted by the prosecution? And as an old prosecutor, previous prosecutor, something that I had often been confronted with in local and children's courts throughout the state. Naturally, the facts and circumstances in each case will be different. The Attorney General in his second read speech outlined potential factual examples which may be used by the prosecution to rebut doli incapax. And I note that Section 5 of the bill outlines considerations which the court must have regards to in determining whether the presumption has been rebutted. That being the conduct of the offending behaviour, the circumstances surrounding the commission of the offence, the child's intellectual and moral development and education, that's if they're going to school, and the environment in which the child was raised. And I note that subsection 6 does not limit, and I quote those words again, does not limit other matters to which the court may have regard. However, the issue I do want clarification around pertains to Section 5, subsection 8, little a, of the bill, which seems somewhat unclear, and it is this issue that I seek clarity from the attorney in his reply speech in relation to a child being given a caution or a participant of a youth justice conference being precluded from being used during part of the decision-making process. It would seem at odds that if doli incapax is to be rebutted by the prosecution, that it is prohibited from adducing evidence of prior police cautions or conferences relied on by the prosecution to rebut doli. And I'd ask the attorney to turn his mind to that when he speaks in reply to this speech. Surely there would be a substantial probative value in having the court take those matters into consideration when determining the issue to assess the state of mind of the young person and to ultimately assist the court in making the correct decision. Of course, it may well be argued that children these days, with the social advancements with education, technology, health, media, etc., that a child in the 21st century are more savvy, informed, educated, knowledgeable and aware than they were 400, 300, 200, even 100 years ago. And this must be a consideration of the courts these days. I wish to also speak to diversionary programs, and it's been spoken about by other speakers, and the important role that these play in addressing youth crime. Positive mentoring, especially amongst young males and First Nations people, is a critical part of addressing youth crime. And we visited and heard from programs like Backtrack, the Clontarf Academy, Boys to the Bush, the NGY program in Orange, that's doing some outstanding work with disengaged boys, keeping them at school firstly, and that's the key. We've got to keep these kids at school to get an education. That's the key. Mr. Speaker, I seek a short extension of time, please.
The question is the member's time be extended. All of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it, the ayes have it.
So receiving an education, being surrounded by positive and enthusiastic mentors. And I note and welcome this government's recent investment into these diversionary programs. And as I said, these are fundamentally important if we are to try and break this cycle. I also note that there is a review provision in the bill that will assess the operation of this part, and I support this, and that will be to hear feedback from stakeholders, courts, police, prosecutors, magistrates, lawyers, community, and to see if this is in practicable terms working. leading to more certainty and consistency in the interpretation of doli incapax, as well as identifying potential any unintended consequences that may have developed during that time. Anything that makes decision-making processes and outcomes more predictable and consistent, and that reduces reoffending is the key important part, is certainly welcome. And it's for those reasons I support the bill.
I thank the member. I call the member